The moment Raymond Colt walked into courtroom 5, he was already 3 moves ahead of everyone, or so he believed. He had the practiced ease of a man who had navigated legal trouble before, the kind of loose-shouldered confidence that comes not from innocence, but from a long history of escaping consequences. His suit was sharp. His cologne arrived before he did. He smiled at the bailiff the way salesmen smile at strangers, wide, automatic, and completely hollow. He had no idea that the woman he had spoken to in the hallway 11 minutes earlier had already told the court officer everything, and he had absolutely no idea that the entire conversation had been captured on the courthouse security camera mounted directly above the water fountain where it happened. Raymond Colt had walked into Judge Frank Caprio's courtroom having already committed a second crime. He just didn't know anyone knew yet, and Judge Caprio, seated behind the bench, reading glasses on, reviewing the morning's file with the unhurried focus of a man who has spent 3 decades learning that the most important information is never what people say first, was about to let him believe that a little while longer. If you can already feel where this is going and your pulse is climbing, you are exactly where I want you. Drop a comment below right now with the word caught, because by the time this is over, Raymond Colt is going to wish he had never walked into that building. And subscribe, because justice, when it finally arrives, is worth every second of the wait. The original case was a landlord-tenant dispute. Raymond Colt owned a rental property on the east side of the city, a 2-family house that he had been renting to a woman named Sylvia Okafor for 4 years. Sylvia, 53, a home health aide who worked 12-hour shifts 3 days a week, caring for elderly patients, had appeared in court that morning in her cleanest work clothes. Dark slacks, a pale blue cardigan, sensible shoes worn smooth at the heel. She carried a manila folder thick with papers, held against her chest the way people hold things they have spent a long time gathering. She had no attorney. She had taken a half-day of unpaid leave to be here. She sat in the front row of the gallery and did not look at Raymond Colt once, which somehow communicated more dignity than anything she could have said aloud. The dispute on paper was simple. Raymond claimed Sylvia owed 3 months of back rent totaling $4,200, and he was seeking an eviction order. Sylvia disputed the amount, claiming she had paid in cash each month and had receipts for 2 of the 3 months in question. The third receipt, she explained quietly when asked, had been lost when her apartment flooded. A flood, she noted carefully, caused by a pipe in the unit above hers that Raymond had been notified about in writing 7 months earlier and had never repaired. Judge Caprio looked at the pipe notification letter. He looked at the date. He looked at Raymond Colt. He said nothing yet, but he wrote something down. That's when the first alarm bell rang, not in the courtroom, but behind the judge's eyes. Raymond had brought his own folder, thicker than Sylvia's, filled with what he described as a complete rental history. He presented it with the flourish of a man producing a winning hand. His attorney, a polished man in a charcoal suit who had clearly been hired to project competence, laid the documents on the clerk's table with practiced efficiency. Rental ledgers, bank statements, a signed lease with highlighted clauses. Raymond crossed his arms and looked at Sylvia with an expression just barely south of contempt. "Your Honor," his attorney said, "the record is unambiguous. Ms. Okafor has been delinquent for—" "I'll get to the record," Judge Caprio said, quietly, pleasantly, with the particular tone that every veteran court observer in that room recognized instantly as a warning dressed in good manners. He turned to Sylvia. "Ms. Okafor, you mentioned this flood. When did it occur?" Sylvia opened her folder and produced a photograph. Her kitchen ceiling, sagging and brown, a plastic bucket on the floor beneath it catching water. She produced a second photo, mold along the baseboard of her bedroom wall. She produced the written maintenance request, dated, signed, delivered by certified mail. Her hands were steady. Her voice was steady. She had been preparing for this day for a long time. Raymond's attorney shifted his weight almost imperceptibly. And then the court officer entered from the side door and handed Judge Caprio a single sheet of paper. The judge read it. He set it down. He removed his glasses and cleaned them slowly, which everyone in that courtroom had seen him do before, and everyone in that courtroom understood to mean that something significant was about to happen. "Mr. Colt," he said, "before we continue with the rental record, I'd like to ask you about a conversation you had this morning, in this building, approximately 11 minutes before this session began. Raymond Colt's jaw did not drop. It did something more subtle and more telling. It tightened, just slightly, just enough. His attorney turned to look at him with an expression that was the legal equivalent of, "What did you do?" Because what Raymond had done, captured in full by the hallway security camera at 8:53 that morning, was this. He had approached Sylvia Okafor's neighbor, a woman named Patricia Dunn, who had submitted a written statement corroborating the flood damage and the unanswered maintenance requests, and he had told her, calmly, quietly, with that same salesman's smile, that it would be better for everyone if she kept her statement vague. He had said specifically that he had friends on the city's rental licensing board, and that he remembered the names of people who helped him out. Patricia Dunn had walked directly to the court officer. The court officer had walked directly to the clerk. The clerk had pulled the security footage within 8 minutes. The courtroom went silent, not the polite silence of procedure, the cold, pressurized silence of a room full of people watching a man realize, in real time, that the floor beneath him has been glass the entire time. Raymond's attorney leaned in and whispered something urgently. Raymond did not respond. He was staring at Judge Caprio the way people stare at oncoming headlights, aware, paralyzed, too late. "I want to be very clear about what the record now reflects," Judge Caprio said, and his voice had the quality of iron wrapped in velvet, smooth on the surface, immovable underneath. "This court has, on camera, what appears to be an attempt to influence a witness, in this building, on this morning, before a proceeding in my courtroom." He let that land. He let every syllable of it occupy the air. "That is not a negotiating tactic, Mr. Colt. That is a crime." Raymond's attorney was on his feet. "Your Honor, your client, Caprio said without raising his voice even a fraction, will have every opportunity to speak, as will the district attorney's office, which this court will be contacting this afternoon." That was the moment Raymond Colt's carefully constructed morning collapsed, not with a bang, with a quiet, precise, surgical statement delivered by a man in reading glasses who had not once raised his voice. What followed was methodical and complete. The rental ledgers Raymond had presented were reviewed line by line. 3 entries showed cash payments recorded as partial, despite matching exactly the amounts on Sylvia's receipts. The bank statements showed deposits on the same dates. The lease's highlighted clauses, examined carefully, included a maintenance obligation that Raymond had violated in writing, in certified mail, for 7 documented months. The flood damage legally entitled Sylvia to a rent reduction under state habitability statutes, a reduction that, calculated properly, not only eliminated the alleged arrears, but meant Raymond Colt owed her a credit. Sylvia Okafor sat very still when the judge said that. Then she pressed her fingers over her eyes for just a moment, just one. The judge's monologue, when it came, was not theatrical. It did not need to be. "Mr. Colt, you came into this courtroom this morning with manufactured documentation, a rehearsed presentation, and, most remarkably, an apparent belief that you could shape the testimony of a witness in the hallway of a courthouse and face no consequences for it. You have spent 4 years collecting rent from a woman who worked 12-hour shifts to pay you on time in cash while you ignored a flooding ceiling and growing mold in the home where she slept. You did not do this because you forgot. You did it because you calculated that she couldn't afford to fight you." He paused. The room did not breathe. "You calculated wrong." The eviction petition was dismissed with prejudice. Raymond was ordered to return the improperly withheld security deposit in full, credit Sylvia for the habitability violation period, and fund the pipe repair within 30 days under court supervision. The witness tampering referral went to the district attorney's office that same afternoon. Raymond Colt's attorney submitted his withdrawal from the case by end of business. Raymond left the courthouse through a side exit, collar up, cologne still there but somehow less effective than it had been that morning. Sylvia Okafor walked out the front doors. 6 weeks later, the pipe was fixed. The mold was remediated. The credit applied to her account erased 4 months of financial anxiety she had been carrying in her chest since the water first came through the ceiling. Patricia Dunn, the neighbor who had refused to be silenced, received a handwritten thank you card from Sylvia that she kept on her refrigerator. Raymond Colt faced a separate proceeding on the tampering referral. His rental portfolio became the subject of a city licensing review that uncovered 3 additional properties with unresolved habitability complaints, 1 conversation at a water fountain, 1 security camera, 1 judge who never needed to raise his voice to make the walls of a courtroom shake, if you felt every moment of that, if you were holding your breath when that piece of paper arrived at the bench, if you exhaled when Sylvia pressed her fingers to her eyes, leave a comment below with the word fixed and tell me what justice feels like to you. Share this with someone who needs to believe that the truth still has weight. And subscribe, because this courtroom has more stories exactly like this one. Stories that prove that arrogance is loud, but accountability is inevitable.